So we're going to take a look at how evidence is admitted into court. So far we've talked about the different types of laws. We said there was statutory law, criminal law, civil law, and common law. And today we're going to focus a little bit on common law and how it specifically affects evidence being allowed into court. Because as forensic scientists, we are very, very interested in how our evidence would be allowed to be admitted into court. So really quickly, evidence is anything that tends to establish or disprove a fact. It can be documents, it can be testimony, eyewitness testimony, it can be other objects, fingerprints, blood, blood spatter, hair, fibers, anything like that, okay? So when we're talking about how evidence can be admitted into court, we need to know what the rules are for getting it scientifically to be allowed in or not. So the first thing that we have to look at are the federal rules for evidence. So in order for scientific evidence to be submitted into a court of law, it has to do two things. It has to be probative, meaning it actually has to prove something about the case, and it has to be what we call material, meaning it addresses something relevant to a particular crime. So for example, if, say, I had committed a burglary, okay, so I had broken into somebody's house and I had stolen $10,000 that was inside their house, okay, and the prosecution wanted to, or the defense, either one, wanted to submit some evidence into my case, and they said, the evidence we want to submit is we want to submit videos taken from neighboring houses. We want to submit the type of car that I drove, and we want to submit their 5th grade school records. Okay, well, if you take a look at all of those and you think which ones actually prove something, which ones are actually material. So the cameras around the neighborhood would be probative, right? That could prove I was on that location. It would also be material, meaning it's relevant to that crime, right? Because it would show whether or not I was there, potentially a suspect in the burglary case. Same thing for the car, right? My car records, if I want to know what type of car, that could prove something. They could take a look at what cars were on the block that time of night, if there were any tire patterns, anything like that, and would also be relevant because it would put me at the scene of the crime. My 5th grade school records would not prove anything and would not necessarily be relevant. One, it would be a long time from now, so that wouldn't be very helpful. And two, whether or not I got A's or F's in 5th grade is not going to be relevant to that particular crime. So those are the things that they take a look at. In order for evidence to be submitted to court, it has to prove something in the case, and it has to be relevant. So those are the first two things they take a look at. If both of those things are true, then they go on to the next rule of thumb. The next thing that they take a look at in terms of scientific evidence are these two cases. So when we're taking a look at scientific evidence specifically, there's two cases that have really influenced what type of evidence is allowed in court or not. It was the 1923 case of Frye versus the United States, which dealt with a lie detector test, and then the 1993 case of Daubert versus Merrell Pharmaceuticals, which dealt with an individual who was suing a pharmaceutical company over drugs they thought had caused birth defects. So let's take a look at both cases and what their effects have been. So in Frye versus the United States, this was the first thing that happened that created a common law. Both the Frye standard and the Daubert ruling are common laws, okay, which we stated before was where a judge rules something and then everybody else follows after that. Okay, so this was a ruling that happened in 1923, and from 1923 all the way until 1993 when the Daubert ruling came into effect, this was the law that was used to determine if scientific evidence was allowed in court. And the guideline was as follows, okay? So this is, remember, for scientific evidence, it stated that evidence had to be well recognized, so it had to be a well-recognized scientific principle, and the method had to have gained general acceptance in its field. So in order for evidence to be allowed in court, it had to be well recognized, okay, and it had to have gained general acceptance. So what happened was in 1923, it was a lie detector test that they were trying to put in. Somebody was being accused of murder, and they wanted to take a lie detector test. And they were saying that the lie detector test shouldn't be allowed in court because it wasn't well recognized or generally accepted. All right? Meaning that not enough people recognized it as good science, and it hadn't been generally accepted in its field as something that was practical. And this went all the way up to the Supreme Court, and they ruled that in order for evidence to be allowed in court, it had to be a well-recognized scientific principle, which means the majority of the people in the field had heard about it, and it was considered common practice, and it had gained general acceptance. It was being used regularly in the field that it was in. Okay? Now, the problem with this is that, for an example, a lie detector test could be considered good science. A lie detector test is well recognized, and it gains general acceptance. People had used it for a long time. The standard doesn't offer any guidance in what we call reliability, meaning whether the test is valid or not, it just means it's being used a lot. And that was part of the problem. The other problem was the jury was the one who would decide if the evidence was allowed to be put in court or not. So what would happen is, say you had a brand new current fingerprinting method that hadn't been used before but was like state of the art, super fancy and working amazing, and you had used it to lift fingerprints at your crime scene. You would offer it into the court, and according to the Frye standard, you'd have to see if it was well recognized and had gained general acceptance. So if it hadn't done those, because say it was a new method, it had only been around 2 years, general acceptance usually takes much longer than that, it wouldn't be allowed in court, whether or not it was reliable or not. It could be a perfect method that could work and have a error rate of less than, 0.2%, and it still wouldn't be allowed because it didn't have general acceptance yet. So the problem was that any new or current science wasn't being allowed in court because it wouldn't be considered well recognized or generally accepted. And some of the older science that maybe was faulty because it was older was being allowed because it was well recognized. And the jury was the one who decided this. Now keep in mind, you always have a jury of your peers. Well, not everyone has a really great science background on a jury, and they were the ones that were deciding this information. So there were a few flaws in this. But it was the common law from 1923 until 1993. So almost 70 years, this was how any evidence, scientific-wise, was allowed in court. Then, in 1993, the Daubert versus Merrell Pharmaceuticals made it all the way up to the Supreme Court. This was a case where a family was suing Merrell Pharmaceuticals because a drug that the mom had been given during pregnancy, they said had caused birth defects. And their scientists had run tests, the defense's scientists had run tests, and they were having all sorts of problems deciding if the evidence could be allowed in court based on the testing. So they took it all the way to the Supreme Court and said that the Frye standard should not be the absolute prerequisite, meaning that there had to be other things that they had to take a look at in order for evidence to be allowed. So they ruled in favor of the fact that there should be other descriptors for what's allowed in court. So now, under the Daubert ruling, which is the new common law, meaning now this is what everybody follows, the judge is the one who has presented the scientific evidence and decides whether or not it should be allowed in court based on these 5 factors. Whether the theory or technique can be tested. Okay, so is it possible for it to be tested, like, say, by both the prosecution and defense? Whether the science that you're being offered has been up for peer review. So has it been peer reviewed by other scientists? Does it have an acceptable rate of error? Does the method have widespread acceptance? So it did take the widespread acceptance and put it in here, but it also included these so that wasn't the only thing that they were going by. And then whether the technique or theory follows standards, which means are there protocols set in place so somebody else could run the test as well. So say we go back to our fingerprinting example. If we had a new fingerprinting technique that had a rate of error that was acceptable, say we ran it 1,000 times and only one time did it come back bad, its rate of error was extremely low, It had been offered a peer review, which means several forensic scientists had used it, had said it was acceptable. It can be tested, meaning that you could test it on multiple locations, just like you would at a crime scene. It enjoys widespread acceptance, meaning there's other people in the field using it besides just you, and that there's proper techniques to follow when using it. So if it hit all of these criteria, the judge would be the one to say, yes, the evidence is allowed in court. So the Daubert ruling just allowed for a couple of things. It allowed for newer techniques and newer science to get in the courtrooms faster. It allowed for some of the older, less credible techniques to be looked at because they wouldn't hit all of these criteria. And it put eyes of the judge on the evidence instead of just the jury, which means that you have somebody who is seeing these techniques being entered into court far more frequently and has a little bit more knowledge of some of this scientific evidence than, say, just a jury would. So in 1993, they switched and the Daubert ruling went into effect, and now every court who has a case that comes up that the evidence is questioned in usually gets overturned, and now they follow the Daubert ruling instead of the Frye standard. So this is like the current common law. I think last time we checked a couple of years ago, there was only like 3 states still using the Frye standard because they hadn't had any cases that had challenged it as of yet. But almost every state in the United States now follows the Daubert ruling as the common law for allowing evidence into court. Okay, so the biggest things to remember for scientific evidence coming into court is that there are 2 common laws that they have taken a look at. Okay, the Frye standard and the Daubert ruling, and the Daubert ruling is the current common law for allowing scientific evidence into court, and these 5 criteria are what it has to meet in order to be allowed in.